Surbhi.
Hi, Sumit. Hi, Sumit.
Yeah. So, good afternoon, everyone. I am Dr. Sumit Pahwa. As an introduction, I have to introduce myself, then I'll introduce the speaker. So, I am a corporate lawyer, company secretary with 25 years of experience in legal and compliance domains. I am currently the co-founder and CEO of Complinity, which is India's leading compliance software, helping companies comply with the laws of India. Complinity covers 2,800 laws and 40,000 plus compliances updated on a daily basis. And we're adding value to 1,500 plus companies in India with more than 15,000 users spread across 100 plus industry verticals like organizations like Panasonic, Max Hospital, Oberoi, Toyota, British Council, etc. I'm also the partner with eMinds Legal, which is a boutique corporate law firm, and also the lead author with Corporate Law Referencer, a leading book on company law. Joining us is our speaker, Surbhi Kohli, who is a principal associate with eMinds Legal. And Surbhi is a corporate lawyer with around 10 plus years of experience into corporate advisory, commercial contract drafting, IPR, labor laws, etc. And she has assisted in several clients in labor and employment laws, privacy laws, legal due diligence, transactions, and IPR. So welcome, Surbhi, to the webinar, and happy to have you and share your expertise and knowledge here with the people.
Thank you,
Uh,
Sumit.
about a little bit brief about the topic is we all know trademarks are essential to protecting the brand identity of any brand and to gain consumer trust. And from a legal perspective, it is governed by the Trademarks Act 1999, and then there were trademark rules 2017. So in today's webinar, in the next 50 minutes or so, we will try to cover the overview of the intellectual property rights and their role in protecting innovation, primarily trademarks. In-depth session on trademarks, practical aspects with respect to certain definitions, types of trademarks, frameworks, registration process, benefits of trademark registration, names, logos, sounds, colors, shapes, what can be trademarked, what cannot be. WIPO, World Intellectual Property Organization, nice classification. How does that relate to the Indian trademark framework? The process, what are the objections that you can receive from the trademark registry? Grounds of refusal, domain names, etc., followed by Q&A. So all this, so we will try to wrap up in 50 minutes or so, 52 minutes to 55 minutes. Then we'll sort of open the house for Q&A also. And just to mention, Surbhi and team have registered more than 600-700 trademarks in the last few years. And some good brand names like Rapid Metro in Gurgaon and Brookfield and many more companies. And therefore, it'll be very nice to sort of see the actual practical aspects in the grounds of refusals and the objections and all that, Surbhi would like to share. So over to you. No, but before I hand over to Surbhi, I'd like to run a very quick poll, just as an opening poll. Yeah. So if you can quickly describe, answer the two questions. Do you have experience in dealing with trademarks? Yes or no? This will help Surbhi to sort of gauge the, the experience of the audience, and accordingly she'll style her content. And what describes you best? So are you a practicing professional or a GC or a legal team or a finance tax team CFO or in-house company secretary or others? So we'll just take maybe 10 seconds for you to fill it up, and then we'll close the poll, and then Surbhi will be starting. Okay, so we end the poll and share the results. 50%, is actually 50%. So 50% say experience in dealing trademark, 50% no. And 28% are company secretaries, 17% are practicing professionals. So we have fair mix of all the people. All right. Okay. So over to you, Surbhi. You can start the demo and not the demo, the training. And yes, for receiving a recording of this webinar, follow us on our channels, LinkedIn, YouTube, and you'll not only get the recording, but many more hundreds of videos are already there for last webinars also, and some nice content. Okay, over to you, Surbhi, for trademarks.
Thank you for the introduction, Sumit. Hi, everyone. Great to be here with you all today. So we'll be beginning with we'll be kicking off things with the basics of trademarks. Let me just quickly share my screen. Yeah. So as I said, I'll be kicking off things with the basics of trademarks, what they are, how they matters, and how crucial they are in protecting your business identity. Even if you're not from the legal background, that should be okay because we come across trademarks in our daily lives in the form of brands, logos, sounds, and even the colors associated with the certain products. For example, Nike's swoosh mark or the brand name like Apple. So this session is designed to simplify those concepts, and I hope by the end of the session you have a clear understanding of all these concepts. To begin with, when we say trademarks, it is very important to know what is a trademark actually. Trademarks are governed by the Trademarks Act 1999 and the Trademarks Rule 2017, which laid out the legal framework and procedures for trademark registration and protection in India. A trademark is a unique sign, name, logo, or symbol that helps people recognize and identify product or service as coming from a specific person, firm, or company. Trademark is defined under Section 2ZB of Trademarks Act 1999 that defines trademark as a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others and may include shape of goods, their packaging, and combination of colors, which covers both goods and services. When in daily life, when people say that it is very important for you to register your mark, the first question that will strike you is, what are the actually advantages of getting this mark registered? So those advantages are as follows. It actually protects the hardened goodwill of the business. It protects the name, branding from being used in the same or similar fashion by any other business firm. For example, PS5 case study. Some of you might be aware that in 2020, this trademark issue was very in light actually in India. So in 2020, Sony was about to launch PS5 console in India. But somehow, because we are in the digital age and you know how fast things moves in the digital age, in 2019, when they start marketing their product, and a person in India, an individual in India, played a smart game and filed an application with the trademark registered with the same logo that PS5 wanted to launch their brand. So when Sony wanted to come to India, they filed an application with the trademark registry, which was actually objected by the examiner under Section 11 that we'll be discussing later in the slides, on the ground that there is already a mark which is there with the registry and it is in the process of getting registered. So ultimately, the PS5 had to then approach the applicant, and then the applicant withdrew its application. Was when PS5 was actually able to launch its brand in India. So that's how protecting your brand is very important, and for the reason why trademark registration is in place. So the minute you start marketing your brand is when you actually start getting your mark registered before any trademark piracy or trademark spotting is being done. Next is it gives product or services a status of branded goods and services that gives an impression to the customers that some standard product or services are being offered. For example, Domino's. Now, when we see Domino's logo, instantly what comes to our mind? Okay, we'll be having a certain pizza with consistent taste and of course with quick delivery. Now, you're not just buying Domino's pizza, you're also buying their brand experience. That's what the power of trademark is. It sets your expectations and customers' trust as well. Next, the exclusive right to the use of the trademark in relation to goods or services in respect of which the trademark is registered. What are the legal requirements to register a trademark? Now, when we say legal requirements, when you file an application with the trademark registry, there are certain requirements that you need to fulfill. First is the selected mark should be capable of being represented graphically. That is in the paper form. For example, if somebody approaches trademark registry and says that, I want to register a smell of a fresh cut grass, that's not going to happen because that smell of a fresh cut grass cannot be brought in the paper form. So anything, be that your color or your logo or your mark that can be brought in the paper form is able to get registered. It should be capable of distinguishing the goods or services of one undertaking from those of the others. So there was a case called as Cadbury Purple Trademark case, wherein the Cadbury decided to get their purple mark, which is there on their wrappers, to get registered. Now, when they filed an application, in the service list they had mentioned, they'll be predominantly using the purple color. Now, the word predominant was something that was a concern for the examiner because the examiner stated it is subjective and vague. You do not specify how much is the color that you're using. Is that 60%, 80%, or major part of your wrapper? So because it was not capable of distinguishing your goods of from the others, that's why their trademark was not registered. The purple case that they wanted to have proprietary on was not given to them. A trademark should relate to goods or services in a way that shows a link between them and the person who has the right to use the mark, whether or not that person is named. Now, when we see a pair of shoes with the Nike tick mark or those three stripes with Adidas written on it, Adidas will not be the right. The Nike swoosh we can take. If Nike swoosh mark is there on the pair of shoes, you'll immediately recognize, okay, these are the Nike shoes that that person is wearing. That's how the mark and the person who owns that mark are linked in between. You should avoid adopting dictionary words or words that describe the quality of goods. For example, best, perfect, super. These are the marks you should not be going, you cannot apply for and you will not have the registration for. There's a tip. If it is a word mark, it should be easy to speak, spell, and remember. The best trademarks are invented words or coined words. Avoid the selection of a geographical name. No one can have monopoly right on it. So, on the sentence of the best marks are invented words and coined words, I just remembered one of our clients was Ajashi. So, we got this mark registered for them. When I discussed with them, why is it that you're using and how did you come to this mark, was when they mentioned that we have a joint family business and the first initial of their name was taken by them to have that word. So that's how coined words or invented words are there. You should always have a word which in itself is very unique and cannot be taken by somebody else. What are the different types of trademarks available for adoption? So it can be any name, including personal or surname of the applicant or predecessor in business, or the signature of the person, which is not unusual for trade to adopt as a mark. For example, use of the name Rajiv or surname Sharma are not allowed. Sharma Smith, we very often come across this word. But then if you want to go ahead and take registration of this mark, it is not going to happen because Sharma phrase in itself is very common. But of course, if along with this Sharma, you have another logo associated with it, it is written in a font which is a different logo with a different style, of course, that can be registered. But simple term Sharma cannot be registered. An invented word or any arbitrary dictionary word, not being directly descriptive of the character or quality of the goods or services. For example, Apple. Now, Apple, when we see is from the fruit industry. Now, we want to go ahead and get a registration of the word Apple in the fruit industry or the food industry. That's not going to happen. But getting the mark registered Apple in electronics industry, like we all know, iPad, iPhones, that's possible because Apple is not arbitrary or dictionary word in that particular line of business. So you can get the mark Apple registered then. Letters or numerals or any combination thereof. Example, 4711 columns. So this is a letter and this is a combination of letter and numeral, which is very unique, not common at all. You can get this mark registered. Devices, including fancy devices or symbols with symbols like birds, like we said, Adidas, stripes. These are the fancy devices. You can get those mark registered. Combination of colors in combination with a word or device. So this plays a very important role when you're filing a trademark registration for a device mark. It is always being advised when you're filing a device mark, people very often come and say that we want a mark in a particular color combination. Let's say in purple and yellow. But then if you get your mark registered in that particular combination, you will only be able to use that mark in that color combination itself. If anybody else is using in any other color combination, you do not have proprietary right on that color. So it is advisable when you are going and filing your mark in the form of a device mark, it should be in a black and white color combination only. When you file it in black and white color combination, you have proprietary over all kind of color combinations. Shape of goods or their packaging is something that you get your mark that can be trademarked. Some marks, when represented in conventional notation or described in words by being graphically represented. So these can be, yeah.
Yeah, Surbhi, on the first one, I had a query. So on Rajiv or Sharma, the example that you've taken, so are you saying that the names can be trademarked? Is that what you're saying?
Yes, names can be.
Right.
But those should not be in the particular business. Like I mentioned, Sharma Sweets is very often we come across, but associated with the logo, we can get it registered.
Mhm. But per se, word marks may not be allowed on name on plain these kind of names, is it?
No, 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 no.
Mhm. All right. Okay.
Moving forward, World Intellectual Property Organization. So this is an organization which is a United Nations specialized agency established in 1967. WIPO works to promote global intellectual property protection through international cooperation and the administration of various treaties. So there are not many treaties under WIPO for which there are signatories, and India being a signatory of one of those treaties as well is the reason why India has adopted WIPO. And when we go ahead for filing trademark in India, there are certain classes under WIPO under which we file application. The NICE classification is an international system created by WIPO to categorize goods and services for trademark registration. It simplifies trademark searches and the application process across different jurisdictions.
Okay, friends, I forgot to mention earlier, if you have any question, please put it in the Q&A box. We'll be taking up Q&A towards the end, but you can keep putting in your questions in the Q&A box. Yeah.
Okay, goods and service marks. Under the NICE classification system, which is there as per WIPO, goods and services are grouped in 45 classes. We have 45 classes in all, wherein classes 1 to 34 are classified for goods and classes 35 to 45 are classified for services. This system actually helps streamline the trademark registration process and prevents conflicts between similar marks used in different categories. Now, for example, when I say classes 1 to 34, class 5 is for pharmaceutical products. So if there's a pharmaceutical company manufacturing goods and pharmaceuticals, then they have to get their mark registered under class 5. Similarly, for services, class 41 is for education industries. So every school getting their mark registered as a logo or a word mark have to get their mark registered under class 41. Similarly, class 44 is for legal services. So every class is designated to a particular product. When you go for filing of a trademark application, you actually have to find out in which classes do you fall is when you get your mark registered in those particular class. When applying for trademark registration, it is crucial to determine the appropriate trademark class before submitting an application, as protection is granted only within the selected class. If you're filing an application under, let's say, class 41, that is education industry, you cannot expect that your mark will not be used by somebody else in, let's say, manufacturing of a machine too, because both the industries are different, audience are different, common public who will be using those marks are different, so there'll be no confusion, and hence you'll not be granted protection in any other class than the class where you have opted registration for. If a trademark is intended for use across multiple classes of goods or services, separate applications must be filed for each class to ensure legal protection for each category. For instance, for both clothing, that is class 25, and retail services, class 35, it must file separate trademark application for each relevant classes. So there can be a scenario when you're filing your application under class 25, like clothing, and you're also providing certain services to the people, which is retail services. So then you would need to file your application in both the classes, is what is written there. Each application is treated independently and protection will be granted within the scope of each class based on the successful registration. There can also be a scenario that your mark is registered in one class but not in other. It is objected by the examiner. That depends because every class, every application is treated by a different examiner and every examiner might have a different point of view. It's when you have to convince them and get your mark registered in that particular class. So what is the trademark registration process? The first step when you go for a trademark registration is trademark research and class determination. What we mean by trademark search is when somebody comes to us and say that I want to get this mark registered, be that a word mark or a device mark, we first search it in the general public if it is already taken by somebody else or if that mark is already there in the process of getting registered. Just like I mentioned about PS5 case, now because that mark was already available with the registry, though it was in the process of scrutiny and in the process of getting registered, you cannot file that application. I mean, you can file that application, but there will be, of course, an objection from the examiner. And then you have to convince your examiner, maybe by saying that you are in prior usage of the mark or how your mark is different. There are also scenarios when a mark similar to your mark is already registered. So examiner will object to that and you'll have to convince examiner. Class determination is under which class your mark will fall. It be that class 1, 2, 5 or until 45. Which classes are those? Then we prepare trademark application in the form TMA. In that application, we mention in detail about your services or the goods because it cannot be subjective or vague, just like we discussed about the purple category case. It has to be concise and to the point. What services are you providing and what are the goods that you are dealing in? So, along with that, besides your services and goods, the proprietor's name, who is the proprietor of the trademark, what is the address for service, who is the legal attorney, your signatures, all of that is covered, along with the power of attorney of the counsel who is representing you. Next step is examination of the application. So when you file your application, the next step is your application is being examined by the examiner. Now the examiner will see if you fall under the category of the marks which are subject to renewal, that we'll be discussing in the next slides, or if the mark is already available with the registry. If it is, then an examination report will be issued and you will have to give reply to that examination report within 30 days of the receipt of that examination report. So this is very time constrained and you have to file that within the set time limit of 30 days only. After the filing of the reply to examination report, you might get a notice of hearing from the examiner when you have to appear before the examiner and convince the examiner why your mark should be registered. After the hearing, if the examiner is convinced, examiner will advertise your mark. Now, what do you mean by advertisement of mark? Advertisement of mark means there's a trademark journal with a trademark registry, which says that wherein all the marks which are advertised before getting registered, the marks are advertised for a period of 4 months when it is open in the public domain. So anybody who sees that a mark is registered with a trademark registry or advertised with the trademark registry and that person is already using that mark, that person can oppose to your mark. Is when opposition comes into place. There's another case of opposition filed with the trademark registry. You'll have to pursue that. And if in case in that 4 months period, you do not receive any opposition, your mark is registered for next 10 number of years. So that's the trademark registration process. Now, what are the grounds for refusal and objection? When can the examiner refuse or object to your mark? Section 9 deals with the absolute grounds of refusal under the Trademarks Act 1999. Trademarks that lack distinctiveness, that is, which are not capable of distinguishing the goods or services of one person from those of the others. For example, cold and creamy cannot be used for ice cream because it is very obvious that this mark is used for ice cream and the goods and services cannot be distinguished from your mark is why this mark cannot be registered. Trademarks which exclusively describe the goods and services, example, kind, quality, quantity, intended purpose, values or geographical origin. Example, acne cream for skincare. If you want to file a trademark for acne cream, you cannot file in the skincare because it describes your goods and services. It has to be something which is not describing your goods and services. Trademarks which have become customary in the current language or the established practices of trade. For example, aspirin was a trademark owned by Bayer for an acid in US, but over time it has been used as a term for pain reliever, so it cannot be registered. Trademarks which deceive or cause confusion to the public. Example, orange juice 100% is a trademark. It cannot, as a trademark, cannot be used on a drink that is not 100% juice. That would be deceptive, suggesting a quality or composition that's not true. So you cannot get that registered. Going forward, there are certain other grounds for refusal, which are trademarks that hurt the religious susceptibilities of any class or sections of citizens of India. Trademarks that contain or comprise scandalous or obscene matter cannot be registered. If the usage of the trademark is prohibited under the Emblems and Names Preventions of Improper Use Act 1950, it cannot be registered. Trademarks which consist of marks of the shape of goods that result from the nature of goods themselves. For example, if for a soap, if you are into the business of manufacturing soap, you cannot register a trademark which describes the shape of the soap, that is square in shape. You cannot get it registered. Next is section 11, which are the relative grounds of refusal under Trademarks Act 1999. So trademarks that confuse the public as it is identical or similar to an earlier identical or similar trademark of goods or services cannot be registered. Like I mentioned, PS5 case, Or when we do the trademark search, we do trademark search on the trademark website, wherein all the marks with their details, what are the goods and services that they are being used. Now, it can be a scenario like you want to file a trademark which is filed by somebody else in a different class. So that's what trademark research is about. You search about that particular mark. Is it registered in your own class, in the business that you are into? If it is, then it is not advisable to go and file ahead because it will be refused. However, if that mark is filed in some other class, let's say in a different line of business, you can of course go ahead and file your mark. You will have the point to convince the examiner and the examiner will be convinced. An exception to this section is if there is an honest concurrent use of the trademark, the registrar of trademark may allow the registration. Example, one mark used unintentionally by two business for a period of time can be granted registration, maybe with territorial limits. Now, let's say if a person is using mark in Punjab and the other person is using in Tamil Nadu. Both are using the mark in the same line of business. There is no bad intentions behind it. You have proofs to show that how your mark is being used prior from the same date, almost from the same date. Those marks can be registered, but a territorial limit can be granted to you. That you will have a proprietary right over the mark only in the state of Tamil Nadu or only in the state of Punjab. So that's how there is an exception to this section. Section 13 and 14 of the Trademarks Act provides that trademarks containing specific names cannot be registered. Trademarks that have a word that is commonly used for any single chemical element or chemical compound in relation to a chemical substance or preparation cannot be registered. Trademarks that falsely suggest a connection with any living person can be declined registration by the registrar unless the consent of such living person is obtained. Similarly, trademarks that falsely suggest a connection with any dead person within 20 years of submitting the application for registration can be declined by the registrar unless the consent of legal representatives of such person is obtained. So when we file trademarks, we think of that we'll be getting that trademark till perpetuity. That is not the case. There is certain duration until which the trademark registration is given, and you will have proprietary for that particular duration only. After that particular duration, renewal is required. So what is the duration and renewal of a trademark in India? A registered trademark in India is valid for a period of only 10 years from the date of its registration. Thereafter, an application for renewal anytime within 1 year before the expiry of the registration is required to be filed with appropriate form and prescribed fee under the trademark rules. So when we say this period of 10 years, when we file an application with the trademark registry, we are required to submit whether we propose to use that mark, that is, from today we propose to use this mark, or are we already prior usage of that mark. If we say we are already using that mark, you'll have to provide certain proofs to the registry to convince the registry, maybe one proof for every year, to say that okay, you are already using this mark from past so many years. So when you get registration, of course you'll be getting registration from the date of certificate until 10 years, but it will say that your mark is registered from the date you started using the mark. So if you say you started using the mark in the year 2000, but you're filing application in 2025, you'll be getting registration for, let's say October 25 is the date when you get your registration certificate. It will be valid until October 2035. But then it will be mentioned that your mark is, you have proprietary over the mark since 2000. So if a person is tomorrow coming and using your same mark and says that that person is using mark since 2010, it is not going to happen because you already have proprietary on that mark since 2000. That's how time comes into picture, and it is very important when you're filing the application, you see what time is it that you're mentioning since when the mark is being used by you. Now, after this period of 10 years is expired, you get a notice from the registry, and of course, you keep a track also of the registration. So, trademark renewal is vital to retain legal protection and ownership. Failure to renew can result in serious risks, including the following: maintaining legal protection. It prevents removal from the register and safeguard exclusive rights. Example, open opportunity to a competitor. There can be a scene when you are into the business of manufacturing goods and there's a competitor who is keeping an eye on your trademark. Now, soon after this 1 year of expiry happens, after your after your mark is expired, that 1 year time frame is also over. That competitor might go ahead and file application with the trademark registry. If your mark
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
mark is not renewed. Later, you cannot come to the registry and say that I had this mark registered since 2000 or I'm using this mark since 2000. I want to have propriety over it. You cannot have it because you were actually sleeping on your rights. You did not file application well on time, and that's how your mark is removed. So it is very important you file your renewal application within the time frame. It supports an enforcement, ensures the right to take legal action against misuse. So if anybody is using your mark and you have that mark registered with the trademarks registry, you can take a legal action against that person. You can file you can send cease and desist notice, and an infringement case with the courts can also be filed in India. So that's how it supports in enforcement. You can enforce your mark, you can get your mark protected by the courts of law in case somebody else is using your mark. It preserves brand reputation, demonstrates commitment to brand integrity, and builds consumer trust. So your trust and integrity is retained in case a mark is renewed on time. What are the consequences and remedies for late trademark renewal? So when I say you have to get your mark registered, renewed within a period of 1 year from the date it is expired, in case you miss out during that 1 year time frame to get your mark renewed, there is also a remedy available for that, which is surcharge for late renewal. If the trademark is not renewed before its expiry, the owner may still apply for the renewal within 6 months after the expiration date by paying the prescribed renewal fee along with the surcharge. So you have another bracket of this 6 months after that 1 year expiry, within which you can file the renewal application, but with a renewal fee along with the surcharge. Failing to renew within the 6 month grace period leads to removal of the trademark from the register. Your mark will be there in the with the trademark registry. It will show if somebody else is searching for the mark, but then it will have a comment that it has been removed. Now it is open for somebody else to register that mark. Next is restoration after removal. Once your mark is removed, you did not file it within 1 year and 6 months thereafter, the removed trademark can also be restored and renewed within 1 year from the expiry. That is by filing Form TMR with the applicable restoration fee and the renewal fee. Restoration is discretionary and subject to registrar's satisfaction that the failure to renew was unintentional, because otherwise you will not have the right to get that mark. Now, when in today's world, we very often see that people change on business and the business is sold off. Then this comes the concept of trademark assignment and documentation. When you say trademark assignment, it means that you're assigning your trademark in all to another person. Now, the proprietor will be somebody else, and in that case, trademark assignment. What we have written here is trademark assignment is the legal process of transferring ownership of a trademark, whether registered or pending, from one party to another. It includes the transfer of all associated rights, such as the right to use, license, or sell the trademark to the new owner assignee. So, trademark assignment can not only be done only for the registered mark. So, let's say you have filed an application and it is still pending for the approval by the registry, because the approval of the registry takes good number of years, even starting from 6 months to even 3 years. So, in that process, if you think that you want to sell off your business or you want to assign the trademark to somebody else, you can of course do that. Trademark assignment is possible. A written agreement, that is a trademark assignment agreement, is required to define terms, conditions, and payment details pertaining to the assignment. This ensures legal clarity and enforceability of the transfer. For the trademark assignment, it is very crucial. It is crucial that a written agreement is there in place. That written agreement is known as trademark assignment agreement. That will actually define what are the terms, since when the trademark assignment is being done. Is it transferred with goodwill, without goodwill? What are the payment terms? Is the consideration paid or is about to be paid? Will be made in tranches, etc., etc. So all these conditions are covered in that written agreement. Lack of proper documentation can lead to invalid assignments and potential disputes. Of course, if there is no trademark assignment agreement in place, and if you have transferred that trademark to, if you have assigned that trademark to somebody else, there can be invalid assignments and potential disputes also. What are the types of trademark assignments? So when we say that trademark is being assigned, first question is, what kind of a trademark assignment is it? Is it a complete assignment, partial assignment, assignment with goodwill, or assignment without? So when we say complete assignment, it means all your rights, use, sub-license, transfer in the trademark, whether registered or pending, is given to the assignee. That person has a right to use, to change that mark, to add more elements to that mark and then get it registered, to further sub-license that mark to maybe for marketing, for selling, for bringing in consumers, or to transfer that mark also, or to further assign that mark to somebody else. So all those rights are being transferred to that third party. When you say partial assignment, it means transfer or limited rights restricted to specific goods, service, or geographic areas, while the assigner retains other rights. Now, you would also want to assign the mark for a particular state. Let's say for Delhi, you want that, okay, this mark can be assigned to a third party who will be using this mark only for the jurisdiction of Delhi. Nowhere outside Delhi can be used by it. That is also possible for a specific goods. Now you have got your mark registered for pharmaceutical and for one more class, which is there in the goods class only. So you can assign your mark for pharmaceutical and not for other classes of goods. You will have your proprietary in the other classes and for the other goods and services, not for the pharmaceutical industry. Assignment with goodwill, it includes the trademark along with the business reputation and value, allowing the assignee to capitalize on existing brand recognition. So you might also want that, okay, I have made a goodwill out of this product for past 10 years. I don't want to transfer that goodwill to the assignee. That's possible. You can mention the assignment agreement that I am assigning this right to this person without goodwill. That person will not be able to market that product further, saying that, okay, this mark isn't being used for past 10 years. He or she will be using that mark only from the date when that mark is assigned as a fresh assignment as proposed to be used mark. Assignment without goodwill, just like I mentioned, transfers the trademark alone, excluding any associated business value or reputation. No business value, no reputation will be assigned to that person. Assignment will be done without goodwill. Next is trans-border trademark protection. In today's world, after this WIPO, World Intellectual Property Organization, the reason why WIPO also came into picture was that in whole world there are a lot many countries, and there can be a scene when one particular mark is being used in India but not in Germany. For example, Zepto is a mark which is at present being used in India, not outside India, and vice versa. Now, if a person who is using, or a company who is using mark outside India wants to come to India in order to register a mark in India, foreign marks must show targeting Indian presence and not just global fame to acquire protection of their trademarks in India. Now, what I mean by this is, now today, if let's say a company names Zepto with a mark similar to Zepto only, tries coming to India and get their mark registered in India, they cannot do that, and they cannot obtain proprietary over the mark which is already in use by Zepto unless they prove that they were already in India, their presence was in India, and the audience was also in India. If they come up saying that we are already using Zepto in US, you cannot expect that you'll be getting your mark in India, and you will getting it proprietary over the mark which is already registered in India. In this, we have a very landmark judgment of Toyota Jidosha Kabushiki Kaisha versus Messrs. Prius Auto Industries Limited. The key issue was whether Toyota's use of the Prius mark in other countries gave it exclusive rights in India. So Toyota had come to India and mentioned that it is already using the mark Prius in other countries in India, while there was already a mark Prius registered in India. So this was a question before the court, where the Supreme Court referred to the UK ruling in Starbucks versus British Sky Broadcasting, emphasizing that goodwill must be proven within the specific jurisdiction. It held that foreign entities must demonstrate a customer base and goodwill in India to succeed in a passing off action. Toyota failed to provide sufficient evidence of goodwill in India due to limited online presence. So at that time, there was no digital era. It has just come into place. So you had to establish yourself by mentioning certain advertisement articles or the newsletters by which you can prove your presence. But they were not able to prove their presence. Minimal sales were there, and the lack of advertisements were also there before April 2001. As a result, the court ruled against Toyota, favoring the territoriality principle over transborder reputation. So even if you had your reputation transborder in India, that's not going to happen. You'll have to prove yourself in India that your presence was there in India. Are domain names protected as trademarks? So this is a very important question when we say domain names. Yes, domain names can be protected as trademarks if the domain name is used in a way that distinguishes the goods or services of one entity from those of the others. So when we say domain names, there is a very important and very landmark case study on this, which was Geo Hotstar case study. So there was an app developer in Delhi who obtained registration of the domain name geohotstar.com before the merger between Geo Hotstar and Disney took place. And when Reliance came to know about it, Reliance approached to that developer and mentioned that this is the domain name that is similar to my trademark. How can you get it registered in your name? So that applicant mentioned that it was something I did it unintentionally and I wanted to register this domain name. If you want this domain name, of course you will have to then take that domain name. You will have to give money to me in return. Ultimately, when this reached to the court, it was proved that Reliance already had marks which were similar to the domain name, and that's how domain name was then transferred in the name of Reliance. So again, like when we start marketing our brands, when we even think of a business, before starting that business, before marketing that business, it is important that you get that mark registered in a and the domain name associated with it registered as well. In case there are certain judgments in this as well, which are in case of People Interactive India Private Limited versus Vivek Pahwa or others, the court gave a proper definition of the term domain name, that a domain name is the territorial address of a business on the internet where it directs a user to a particular part of the web where the particular domain name of the registrant stores and displays all necessary information, offers, and service available on the internet. Another case was CLR Productions Limited versus Gaurav Mehrotra and another. The court held that a domain name is more than a web address. It provides information about the owner's goods and services. Therefore, the owner can seek protection of its domain. So whenever we are going to register the trademarks, few questions have to be there in your mind. What is if you need a word mark in protection, if you need a logo in protection, or if you need a particular domain name in protection as well. I, being a lawyer, will obviously suggest that your mark should be protected in all aspects. If you think that it is a word mark, for example, if you take the mark Adidas in question, now if this only the word mark Adidas, Adidas, that should be registered, then Adidas with those three stripes as a logo should also be registered. Along with this, if there's a domain name, that domain name should also be registered. All this should be registered considering in mind what all classes are there. That class search is very crucial. You'll have to register your class, and that's of course where the attorneys come into pictures. In India, that class search is under WIPO, just like I mentioned, and that WIPO classes should be analyzed properly to see if advertisement services are also provided to you, like advertisement and office office pens, diaries are something which we very often use in our office. If we have a brand, we would like to use that brand in the office dictionaries or office usages as well, like diaries, pens, and all those things. So class 16 comes into pictures. So all these classes are something that we need to analyze properly before we go ahead and file application. This also becomes very important because amendment can be done, but amendment cannot be without amendment can be done, but not just like that. Amendment has to be proper amendments, otherwise it is not going to happen. Just a second. Okay. So this was the overall crux that we had, where we explained about the trademarks, how those are beneficial, and how those domain names can be protected.
Surbhi, before you start with your quiz, may I request the Complinity team to switch on the chat box also? So enable the chat box for the audience. So as Surbhi lays down the quiz and questions, you can keep responding in the chat box, not in the Q&A box. Your answers of yes, no, whatever you feel like. So Nandita, if you can just switch on the chat box, please. And also, could you confirm when done?
Yes, Sumit, she's doing it.
Yeah, okay. We'll hold for 5 seconds.
Yeah, it has been done, Sumit.
Done? Okay. So as Surbhi gives the question, you could please use the chat box to give your responses. And Surbhi, you can also sort of see audience's responses also. Okay, go ahead.
So the first question is is the trademark liable for removal on the ground of non-use?
Yeah, so
Okay.
let's wait for the answers. No, hold on. Hold on to the
Yeah,
first question.
yes.
Let's wait for the
Yeah.
answers. If you could, friends, put it in the chat box. Yes, no, whatever you feel like. Is the trademark liable for removal on the ground of non-use? Okay. Or any thoughts very quickly? Okay, so people are saying yes, no, no. Okay, we see more no's.
Yeah.
Only one yes. Trademark liable for removal on the ground of non-use. Okay, mostly we're receiving no's. Okay, Surbhi, answer.
So the answer for yes is yes. Your trademark is liable for removal on the ground of non-use. This is, would be surprising for all of you because if you get your mark registered and you're not using that mark, somebody else wants to use that mark. And if that person sees what is the market value you have with the mark, how often are you using that mark? If there's no proof for that, that person can approach to the registrar. The registrar can call you, send a notice to you, and you will have to actually prove that you are not using your mark or were you using your mark. If you're not able to prove yourself, then your mark will be removed and the other person will get right on that.
Oh, that's a big one actually, because you're saying that not only you can sort of register and block the mark, but you need to be using it. And if you're not using it and somebody else wants to use it, then it can like result into a sort of an opposition where you can be sort of asked to deregister, is it?
Yes, that's right.
Okay.
Yeah.
Oh, that's an important one. Okay, go ahead.
Yeah. So the next one is, can a registered trademark be amended at a later date? Once it is registered, if you want to amend it, can you do that?
Okay, answers please, audience. Can a registered trademark be amended at a later date? Okay, so most of the people are saying yes, but we have one no as well. But mostly it is yes. So Surbhi, what's the answer?
No, that's the answer is no. Once a mark is registered, you cannot amend it at a later date. The
Oh,
reason is the proprietor can be amended, it can be assigned, but the mark for which you have the registration number also, it can never be amended. If you want to amend it, you'll have to file a fresh application.
wonderful. So see, these are so important questions where, it's very counterintuitive. Looks like if the answer looks like yes, it is no, and vice versa. So, okay, looking forward to the third question.
Yes. Can an unregistered trademark be protected?
Okay, friends, answers. Unregistered trademark, can it be protected? So a lot of people are saying no. I'm suspecting the answer could be yes. So, okay. I think we have more no's than yes. So, but yeah, some people are saying yes also. So what's the answer, Surbhi?
So the answer is again the opposite of the majority. The answer is yes, the unregistered mark can be protected as well. So even if you have your mark since years that you're using your mark and you do not get it registered, you will get that mark protected. That's when I also mentioned in the transborder transactions, if you prove your presence in a particular area where you want to get your mark registered, you have proprietary on that mark. It is not important that you have to register your mark. Of course, for registered marks, there are certain other associated benefits, but with the unregistered mark also, you have the protection available.
But Surbhi, I'm assuming there would be a caveat here because if let's talk of India only, not transborder. I'm not complicating. So I'm saying that if I have an unregistered mark and somebody else has a registered mark, but I'm using an unregistered mark and somebody else is also using, but maybe slightly lesser, but his mark is registered. So wouldn't he have a better protection, since his mark is registered?
No, so again, that unintentional concept also comes into picture. If you both are using the mark unintentionally, you both can have the right. And second, the very important factor is the time since when you're using your mark. If you're using your mark since 2005 and that mark is registered in 2025, you want to register your mark today. If you approach the registry, of course, you will have the proprietary right than the person who has already registered its mark.
Yeah, but then it becomes litigative, burden of
Yeah,
proof, and
yeah.
all those things.
Yes, yes,
And
yes.
some bias will go to towards because otherwise, then what's the means if somebody who's got it registered very legitimately using it, and somebody who's not got registered, there would be it will become hugely litigative in a trademark litigation.
That of course will go to courts, but then if you're using, you have evidence that you're using your mark since so many years, you have that reputation in the market. So that will also be considered while considering the case.
Okay. Okay, go ahead.
What is the difference between license and assignment of a trademark? So more than a quiz, this is actually an answer that will need a detailed response.
Yeah, but why don't yeah, just need but why don't you just articulate, Surbhi? This was in fact my question also. I was about to ask this question. Good that you put it this way. So yeah, if you could answer right away.
So license and assignment are a different concept. License could be for certain number of years, only granting certain rights to the licensee. However, assignment is forever. You cannot assign for a certain number of years. Assignment is registered with the registrar. I mentioned that assignment agreement has to be in place. For license agreement need not be in place. You need not go to registrar because license today you're licensing to one person for, let's say, you want to market your product in the market. You then in case you'll be licensing your product to a particular marketing agency. But then tomorrow after 2 years, you would need another marketing agency. So we need not register this license with the trademark registry, but assignment is forever. You need to get that registered with the trademark registry by filing that assignment agreement. That's how both these are
Yeah.
different.
Put otherwise, if somebody is selling the trademark to somebody, then that sale takes place in form of assignment, which is registered with
Yes.
the trademark registry, right? Whereas
Yeah.
license is a time-bound,
Permitted use. Yeah.
temporary, probably revocable license to use somebody's mark, right?
Yes, that's right. Yeah.
Yeah. So yeah, there's a comment called ownership versus mere rights transferred. So in assignment, I think the ownership of the mark goes, whereas in license, only certain limited rights are licensed. Yeah.
Yeah.
Okay. Next question.
Okay. Next is so sweet. What is the difference between infringement and passing off in a trademark?
Yeah.
So
You can answer that as well.
answer that also. So when you say infringement,
Or let us take this as a text quiz only. So yes, anyone would like to put it in the chat box in difference between infringement and passing off. One line answer only. We are not asking you to write an essay, but yes, any one line or differentiating line between what is infringement and what is passing off. I'm sure a lot of legal professionals and company secretaries would have read it, but somebody who's not practicing it, in case you remember. Practitioners, of course, would know it by the back of the palm. Maybe people are typing. Let's see who press the enter first, fastest finger first. I'm hoping that somebody's typing. Yeah, here we have the first answer. Infringement is unauthorized use if trademark, whereas passing off protects goodwill of unregistered trademarks. So it is slightly confusing. Surbhi, only if you could sort of articulate and clarify.
so when we say if your registered mark is the only mark that is being protected, and we say unregistered marks are also protected, if somebody is infringing your registered mark, is when you file a suit for infringement. You send cease and desist notice, and an infringement suit is also filed. However, if an unregistered mark is being used by somebody else, you still have the legal remedy available with you. That is passing off in trade. In that case, you file a case for passing off that your trademark has been passed off by that entity. So that's the difference.
Right.
Infringement is for the registered mark remedy, and passing off is the legal remedy for unregistered trademarks.
Understand. Okay, Complinity team, if you could switch off the chat box. Now, if anyone has any more questions, we have few questions in the Q&A box also, which I'm going to take in a while. So please switch off the chat box. What I'm going to do now is we've got, yeah, by the way, Yeah, you can show that thank you slide, Surbhi. Yes.
That has been clear. So I'll say thank you to everyone. And for any queries, you can of course reach out to us at ipr@emindslegal.com.
Yeah, please note down the address, and I can vouch that eMinds Legal has registered more than 700 trademarks in the last few years, and they'll be most happy to sort of answer your queries or help you with any of the trademark registrations. Now, I want to spotlight one audience. I know one audience, and let me just find if she's here for one very interesting perspective. So, Suruchi, if you're there, I am promoting you to a panelist. Let's see if this works for the time being. Yes, we have one more panelist. The audience promoted to a panelist, Suruchi. Suruchi, can you switch on your camera? Okay, good. So we have Suruchi as well. Suruchi, no, we can't hear you. Maybe you're on mute.
Yeah, slightly audible.
Yeah, can you just increase the volume or something? Friends, just bear with us for 10 seconds. Yeah, Suruchi, can try speaking?
Yeah, am I audible now?
Yes, very, very, very clearly. Surbhi, you can unshare the screen.
Yeah.
So let me just introduce Suruchi very quickly. Suruchi is a senior associate with eMinds Legal. She carries some 5-6 years of experience as a company secretary, and she handles a lot of incorporations and corporate law compliances at eMinds Legal. I just spotted Suruchi, so I thought we'll spotlight Suruchi for one perspective. Suruchi, when we go for incorporation of companies, also there are a lot of objections from registrar of companies from the MCA on that the name is somebody else's trademark. So I believe some trademark searches are done by them, and then they. So, what is your experience, if you would love to share on company incorporations? What is your incorporation of company law vis-a-vis the Trademarks Act with respect to the names of the new companies? If you could share.
Thank you, Sumit, for the introduction. Hi, everyone. So, as per my experience, whenever we go for the incorporation of a company, the first step is to do a preliminary research on the name availability of that company, which is done on the Ministry of Corporate Affairs portal. So there, apart from the name check, it is very important for us to check whether that name has been applied as a trademark by anyone on the government IP search website. So, in case I'll give an example, if I have chosen a name as Zentech Private Limited. Now, if I type the Zentech Private Limited on MCA, the name is available. No such company is registered with the name. But if I go for searching the trademark for that, in case anyone has applied with the word Zentech, maybe with a space between Zen and Tech, or a single word Zen or a single word Tech, then under the same class of the objects that the company will be proposed to do after incorporation, then there are chances of getting a resubmission from the authorities, from the Central Registration Center, MCA. So it is very important under that particular class, we go and check under different combination of names or similar names with a space, without a space, or that whether a trademark has been registered or has been applied for or has been objected for.
Right. Perfect. Thank you. Thank you, Suruchi. I think this is a useful perspective intersection between company law and trademarks, and how important this is. So thank you, Suruchi. Okay, so friends, we arrived towards the end of the session. I'd also like to share a few things. Suruchi, you can be here with us. Yeah. And also I'd like to share one more thing. Let me share my screen and show you something interesting. Yes. 1 second. Okay, can you see my screen, Surbhi?
Yeah.
Yeah, so this is a book called Corporate Law. This is Corporate Law Reporter. This is our portal. There's another book called Corporate Law Referencer, which is also, I opened the wrong one. But anyway, this is a book called Corporate Law Referencer. And this is authored by us, by eMinds Legal. You can see the logo. This is the 11th edition. I'm drawing a parallel with the trademark here. So you can see an R in circle over here. So, generally, the names of the books also become generic, and say Companies Act or Referencer on Companies Act, or it's like subjects, and they're not trademarkable. However, this corporate law referencer has acquired quite a good distinctiveness, it being the 11th edition, it having sold more than 10,000 copies in India, and it's one of the leading books on company law in India. And by the way, we have just released our 11th edition a week, 10 days back only. So not only it's a best-selling leading edition, but also it got the, we got the trademark of the title, which is very, very unique. And by the way, Nandita writes, you can also order, by the way, a copy of this book. The links are mentioned. You can get some discounts and free shipping all over India. That's on corporate law referencer. Now I'll have my team just play a 1 or 2 minute video, and we'll take a couple of more questions and then wrap up the webinar in the next 15 minutes or so. Over to you, Complinity.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.
Right, so that is Complinity. As I said in the beginning, it's India's leading compliance software being used by more than 1,500 companies, covering more than 2,800 laws, 40,000 compliances. Of course, not everything applies to every company, but it helps companies comply with whichever laws are applicable to that company, whether you are a hospital or a healthcare or pharma or auto or manufacturing, etc. You can use this software. And it is AI also is getting integrated within the tool, and it's a wonderful tool. So anyone who wants to request for a demo, the links are already here in the chat box. Right now, just if you go click, just mention your name, number, etc. in the form, and our team will contact you for the demo. Okay, coming to the questions. Now, there are a few questions. Surbhi, I'll ask you the question and request if you could sort of answer. Now, first question is it possible to register a trademark application in India if it has been registered and approved in US by parent company?
So yes, if a mark is approved and registered by the parent company in US, it can be registered in India. But then you will have to do the trademark search again. You will have to see if that mark is already being used by somebody else, or if it is falling in the grounds of refusal that we just discussed. If it is within those categories, you cannot register. Otherwise, it is very well open to be registered.
Right. Next is please brief about multi-class application. I think that's a wonderful question. Multi-class application, what is course of action available if registration of the proposed trademark under a multiple class application is opposed in single class?
So there is also a concept of filing multiple classes in one single trademark application. That is also done by people, which is not advisable by me individually, I would say, because every class is, like I mentioned, is judged independently. If you have filed different applications, each application will be judged by the examiner. There can be a scenario one is registered and one is not. But if you have received objection in one and not in the others, you will have to convince examiner. And there is also one more ground available to you. You can also convince examiner saying that, see, I have already obtained registration in other classes. The examiner will note down your your registration number. It will be also considered, and more often your marks are also associated. It is also written by the examiner in the final order that your mark will be associated with this mark because that mark is registered in this particular class. You will also get registration in the other class. So that's how multiple classes functions.
Yeah, so what you're saying is it's advisable to go for single classes, because even if
Yes,
one
yes.
gets rejected, the other may be approved, and even the associated classes may get some good value in the other classes registration. So
Yes.
that is, but the second part of the question was, what if in a multiple class application, you file a multiple class, but the opposition comes from a single class, some other party. So what happens then?
So in that particular class only, you will have to go for that opposition suit. For rest of the classes, you have registration. So that's not a concern. Maybe that opposition is filed for in a particular class because that person is selling goods or providing services in that particular class only. So for rest of the classes, you are well to go ahead and use that mark.
So probably in case the other party wins in a single class, maybe the multiple class you will not get registration in that class which was opposed,
Yes,
and if
yes.
the other party wins it, but in other classes you will win it, right? Isn't it?
Yes, yes,
You
that's right. Yeah,
Okay,
that's
next
right.
is which is the most secure trademark class type? It's a I'm laughing at this question. One, it's a cute question. Most secure, I mean, all 45 are equally secure or equally insecure. Should first priority be given to the trademark, the name, device, or logo?
I
I think
think,
let me answer this
yeah,
question. So I think there is nothing called insecure or insecure. Yeah, I think what is important is relevant or non-relevant. So if you are manufacturing oils, you can't say no class. The class of pharma is better. So let me, that is more secure. No, nothing like that. Each class describes the types of products from class 1 to 34 and services from 35 to 45, and you have to file where you fall in genuinely, because you have to give proof of usage also. And nowadays with the trademark hearings at almost at all the in all the cases, trademark objections come, you have to give examination reports come, you have to give the replies, and hearings also happen in most of the cases, etc. So something which is more relevant where you can prove is what is important, rather than the class, rather than which is more secure. And second is name, device, or logo. I would say, I mean, logo. I mean, all three are registrable. But yes, if you have a unique word per se, and you can go with both or all also. So word mark and logo also can be registered separately. So if you'd like to add anything.
yeah. So I'll take up the second question first, word, device, or logo. So if you take proprietary on the word, let's say eMinds legal is the word mark that we have registered into. We can use it in different font. We can use it upside down. We can change the font size also. So that can be done. It is the purpose of getting the mark registered as a word mark. When you register it as a device mark, you cannot change that mark. It is actually the logo which you'll affix wherever you want to use that. So it also depends on the person to person, but I would advise that it is registered in both cases. If you have a specific logo attached with the word mark, it should be registered in the form of a device mark. Otherwise, the word mark will also go. That's also possible. As far as the first question is concerned, which was that which class is
Right.
secured,
Yeah.
you have rightly mentioned. I think, yeah. So as far as the secure classes are concerned, there is no such secure class. You have to decide your business. The business that you are dealing into will decide what is the class that you want to go ahead with. Be that a pharma or manufacturing unit for clothing industry, apparel industry. If you're dealing in apparel industry, you won't go in the oil industry. So that depends on your business that you are into. First, decide your business and the class will go on. You can get it registered in that particular class.
Yeah, and one can go in multiple classes also. Sometimes
Yes.
multiple classes make sense for one particular business, and that's the job that eMinds Legal does for its clients when the logos or the word marks come. So first thing is to do the search. Second is to advise on which classes, and then the assignment starts. Okay.
Yeah.
So there'll be a few more questions. So, can colors be trademarked? You had a slide on purple. You mentioned about Cadbury's purple color, or I can also draw parallel between, the Domino's, the blue and white, the colors indicate the brand very quickly, or sometimes the orange of orange of Swiggy, or the red of Zomato, or the pink and blue. I remember of Vishal Mega Mart, the carry bags that we used to have. So can colors be trademarked as such?
Yes, they can be. So just like I mentioned, if you register your mark in a particular color combination, you will have the right to use that mark only in that particular color combination. Like Vishal Mega Mart, pink and blue. So they can only use their mark in that pink and blue color combination. They have their right. Nobody else can use their mark in the same color combination. But like I mentioned, if they use it in black and white, you have rights over all kind of color combinations, not
So
just
that is
pink and blue.
fine. Surbhi, that is understood. But what my question
Yeah.
again, the question on top of it is, for example, the if you just say the pink and sky blue of the Vishal Mega Mart carry bag. Now, okay, the Vishal Mega Mart logo can be in black and white and say all colors are protected, but that unique color combination, the color itself, tells you that, this is Vishal Mega Mart, for example. So can somebody trademark the colors itself, the pink and blue? Can other people print the pink and blue carry bags in the same fashion? Forget the logo and the mark.
Yeah,
Or
color,
the
if they're
purple,
using it,
or the purple wrapper of Cadbury, for example. Can 5-star also use the same purple wrapper just like Cadbury and mention 5-star on it?
yes, 5-star can do that. The reason why Purple Cadbury case was in picture and why their mark was registered was in the services they had mentioned they want to use it predominantly. So that was subject. That term predominant was not mentioned clearly, that how much is the color that you're using. 60% of their mark is in purple color, 80% or majority part of it. So you have to be very clear and concise, and you can use that mark. Similarly, if you are getting mark registered in purple and pink, somebody else can use it in the same fashion. So not that color combination is a propriety you have, but color combination along with the logo is what you have your rights on.
Sure. Okay, there's another question called restoration of trademark. It was mentioned in the PPT as 1 year from the date of expiry. Is it after 1 year period provided to submit renewal application, or after extra 6 months grace period with additional charges allowed to submit application? So maybe you could touch base on the renewal.
So restoration, yeah. So restoration is done once your mark is removed. Your mark is removed after that. First, that 1 year expiry, one year period is there when you have to renew your mark. With simple renewal fee. After that 1 year expiry, you have another 6 months to give that surcharge fee and get your mark renewed. After the expiry of 1 year and 6 months, your mark is removed. Once that mark is removed is when restoration comes into picture. So restoration is after all your remedies are exhausted, and that can be done only when your intentions are clear. Yeah.
Sure. Okay, next question is, how much time does it take, from filing to registration normally nowadays?
So nowadays, trademark registration process, though the registry has been trying to wrap it up really fast, but what we have seen is, if in case your mark is very unique and it is a coined work, there is no similar mark registered in the trademark registry already, no pending application is there, it can be registered within 6 months, because that's when the examiner scrutinizes your application and responds with the examination report. However, if there is a mark already in place, you fall under the other categories of refusal, you'll have an examination report, and it might go on to 3 years also. There are instances when even 2 or 3 times an examination report is issued, you'll have to give replies, and for hearings, there is a considerable amount of time which is taken by the registry. So 6 months to 3 years, I would say.
Is there any percentage you would like to sort of pick, in terms of success percentage, filing versus registration? Surbhi, in your experience of registering hundreds of these marks, means not to indicate, means generally in your experience, what is the success percentage of registration of marks at a very, very high level?
I would
Is it
say,
like 80%, 90%, 50%?
yeah, more than 90%, because when we get a request from the client, it's when we start our work, we do research and the class search very proper, that at the end we actually know what is the objection that is going to come from the examiner. So we analyze that, sit with the clients. If it is a proposed to be used mark, we even suggest that you change your mark, or you think for something else which can be registered easily. So after all this homework, we go ahead and file application. So the success rate is more than 90%.
Yeah, so I think the key is that if the homework is done well, and if the preps are done well in advance in terms of trademark searches and the classes and the advices and preempting the objections, then I think the success rate could be higher, right?
Yeah, that's right.
Would you like to throw a light on well-known marks, Surbhi? What are well-known marks?
So well-known marks are which are already for example, you mentioned Domino's. So marks which are there in the market for good number of years, so let's say 10 years, 20 years, and they have actually monopoly on that industry. Now, when we see pizzas, there are 2, 3 names which should come to our mind: Domino's, Lapino pizzas. So even if there are new pizzas, startups coming up in place, you will always prefer these marks over the marks which are there. So these are well-known marks. Even if you have Domino's in you want to have that domino mark registered in other class, you cannot do that, because that mark already has a well-known established market in the pizza industry. So that's what well-known marks are.
Yeah, but is there any criteria or threshold for what is well-known? When you say established, means what is established? Is there any criteria defined in the act or rules?
No such criteria defined in the act. It depends on how the mark is being used in that particular geographical area, and how long since that mark is being used in that. So
Understand. These are facts and circumstances of each case, which maybe the trademark registry will take into account while
yes.
giving those things. Yeah. All
Yeah,
right.
that's
For example, on a lighter note, we have, of course, Reliance would be a well-known mark in India. Who doesn't know Reliance? But of course, in the old Gurgaon, I saw a shop called Reliance Tailors. So, those kind of things,
happen.
but he may not have gone for a trademark registration, so that's fine. So, okay,
Yeah.
so since you mentioned about startups, so are there any special benefits for startup companies for trademark registration?
Yes, so trademark registry do provide a lot of benefits. One of those benefits is when you file the trademark application for every company, it is 9,000 per application, but for startups, they have a reduced fee of 4,500. So that fee is also reduced, and then after the registration also, this is for everybody. I would say for trademark grievance portal is also there, where grievances are solved. Even before going to the court, people very often say that cost is associated with the trademark filing, and if your mark is infringed, there is a lot of cost. But now grievance portal is there. You can approach to that grievance portal. You can file your complaints database, sending an email, and trademark registry will take it up. So this is, though on another note, this is applicable for all the companies, but for startups, that time period, that fee structure is reduced for
4,500, and I think not only startups, even MSMEs,
individuals.
also
Yeah,
individual
MSMEs and
MSMEs,
individuals.
yeah, same reduced fee. All right. Okay, so I think we have almost reached towards the end of the webinar. I think one last question I'll take. Which trademark type is most preferable, device or word? Although there's no straight or easy answer to this, but yes, any pick on that.
Again, so word mark, if you just want a particular word to be proprietary on, no specific elements, added elements to it, like Apple, APPLE is the only, these letters are the only letters that you want trademark on, go for word mark. But if you want added elements to it, slightly a font size is changed, or font style is changed, certain added elements like a photo is there, a symbol is there, then of course a device mark would be required.
Understand. Okay, before we end, let me just launch another poll. You saw a video about Complinity and you got a brief also. It's India's leading compliance software. So anyone would like to have a demo of the Complinity compliance software, please indicate yes or no. And also, would you like to be a future speaker in these webinars? Please indicate. In that case, we will sort of invite you to be one of the speakers. So very quickly, if you could indicate your preferences here. And any last word, Surbhi, on the topic? Any closing remarks?
Yeah, so while discussing, there was one case that was in my mind. I just missed discussing that. So trademarks today are important to be registered, but at the same time, while using your mark, it is very important you do homework. You see if there's any other mark which is in use or not. Like recently, Delhi High Court had issued an interim order against the Oscar-winning A.R. Rahman and a production house, which was not a small amount. That was somewhere around 2 CR, because they had used a song in their Tamil movie, which was not just inspired but totally identical to Shiv Stuti, which was produced by Junior Dagger brothers. So that's why in today's world, trademark is such an important issue that first you protect your mark, and second, while using any mark, you should be aware if that mark is already in place or not, so that you're not infringing any others. So yeah, that's it.
Okay, on that note, Surbhi, thank you very much for a wonderful session. I think this was very enlightening. I learned a few things as well, and I'm sure the audience also would have enjoyed the session. So thank you, Surbhi, and thank you, audience, for a patient hearing. And thank you, everyone. Thank you, Complinity team, for organizing and support. Thank you. Bye.
Thank you, Sumit, for having me as a speaker. Yeah, thank you.
Bye.
Thank you, Complinity.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.